I'll be covering provisions pertaining to union territories and also the specific provisions which are there for Puducherry, for National Capital Territory of Delhi, and also the friction points which were there between LG and Delhi government and the Supreme Court judgment. Basically, I would like to touch upon comprehensively these aspects. I would advise you just to take bare act of the Constitution and the articles which I am just mentioning here, just note them down, flag them in your Constitution in the bare act which you are having, and I advise that as the lecture progresses, please refer to those articles. It will help you in understanding them and in recollecting them later on when you study the other aspects. So the articles which I'll be covering, you can note down are, I'll just mention here in a box. I'll be mentioning Article 1. Article 1. I'll be mentioning Article 246 Clause 4. I'll be also referring Article 164 which pertains to the state. I'll be covering Article 239, Article 239A, Article 239AA, particularly Clause 3 and 4, and I'll be covering Article 239AB and Article 239B. So these articles I'll be covering, and also the 7th schedule, or let me write like this, 7th schedule and the 12th schedule. Particularly the entries 1, 2, 18, 64, 65, 66 of the 7th schedule, and the entry related to fire service for the 12th schedule. 12th schedule basically is for the local bodies, the municipal bodies. Now when we talk about union territory, we have to refer to Article 239, which is the source of understanding what is the constitutional scheme as far as union territory is concerned. Now, Article 239 says that the administration of union territory shall be done by the president through an administrator. It is in my language I am saying. When you read the language of the article, it will be different. But the essence is that their president will administer the union territories through administrator. So when it says president, it means the union government, because president will not be acting in his discretion. So President acts on the aid and advice of Council of Ministers, that is the union government. So President will be acting means it is the government of India which administers the union territory through an administrator. It is a different matter. This administrator is called LG in case of National Capital Territory of Delhi and also Puducherry. Now if we go further, that is the broad mention about the union territories. Now union territories, they are administered by president, means the union government, that is clear from Article 239. But who makes, which body is empowered to make laws for the union territories? We have a federal scheme of things where union government makes laws for the union list, state government makes laws for the state list, and both the state and the union can make laws for the concurrent list. When I say government means I say parliament. As when I say law making and I say government, it actually means parliament. So law making is done by the parliament or the state legislature. But who makes laws? Which laws will be applicable as far as the union territory is concerned? So Article 246, when it divides, it distributes the legislative competence of the union and state governments. Clause 4 of Article 246. Article 246 is linked to the 7th schedule. So Clause 4 of Article 246 very clearly mentions, so Article 246 Clause 4 talks about those territories which are not part of the state. Means there are states there are union territories, and there can be acquired territory, one more category. There are states, there are territories which are not in the states. If you read Article 1, that is why I mentioned Article 1, India is a union of what? It is states, it is territory which are not in the states, and the third category is the acquired territory. Now, reading Article 1 and then you read Article 246, Clause 4, which says the territories which are not in the state, for those territories, Parliament is competent to make law even on the subject which is mentioned in the state list. So it is very clear, Parliament has competence to make laws for the matters which are mentioned in the state list as far as the union territory is concerned. That is the general provision. Parliament administers the union territory through a general provision of Article 239. So general provision Article 239 and Article 246 Clause 4. But there is a distinction, there is a separate provision for Puducherry and National Capital Territory of Delhi. They are a distinct, these two will fall into distinct categories within the whole set of union territories. So you have union territories also. So out of those union territories, as far as Puducherry and National Capital Territory of Delhi is concerned, there is a separate provision in the constitution. And what are those? 239A deals with Puducherry and 239AA deals with National Capital Territory of Delhi. For Puducherry, you don't have a comprehensive scheme as is provided in case of National Capital Territory of Delhi. Article 239AA is much more comprehensive, is much more broader, explains more areas as compared to Article 239A. Article 239A only empowers the Parliament. It gives powers to Parliament. It doesn't create legislature for the state. Like in case of Delhi, Article 239AA, I think Clause 2, just check, maybe I think Clause 2, just refer that clause, provides for the Legislative Assembly. But here it tells Parliament to make law, to constitute a body. It doesn't say that Legislative Assembly. It talks about a constitution of a body which will function which will have the legislative powers. The exact language you can check, but it doesn't say Legislative Assembly as it says in case of Delhi. So it says body. It can by law create a body which can be partly elected, partly nominated. It can also create Council of Ministers. So a body for legislative purpose, there will be a body and there will be a Council of Ministers. It can be either a body, either a Council of Ministers, or both. So that is not provided in the article, but it is that power, this article gives that power to the Parliament to make law and create this. 239AA itself creates a Legislative Assembly for Delhi, and there it very clearly provides that what is the mode of creation of that assembly. It will be by election, and what will be the type of election? It is direct election, very clearly mentioned, direct election. Now once you create a Legislative Assembly, you have to give powers to the assembly. You create a body for legislative purpose. You have to empower it. Empower for what? You have to empower it to make laws, and that empowerment is given by Article, so 2 I have covered. Now I come Article 239AA, same article, Clause 3. That is the competence of the assembly. In what areas this assembly can make laws. So law-making power is confined to the subjects which are in state list of 7th schedule. Only those subjects insofar they are applicable for union territory. This language is very important. Even Supreme Court has taken note of that. It is not all 3 subjects are excluded. I'll come to that. 3 subjects are clearly excluded. 3 other associated subjects are also excluded. So we can say 6 subjects are excluded, 3 directly and 3 indirectly. 6 subjects are excluded by this article itself out of the state list. So Legislative Assembly does not have any power to make laws on those subjects. But even on the other subjects, means the remaining subjects, by excluding those 6 subjects, only those subjects insofar they are applicable to union territory. Like for example, Article 41, which deals with the state services. So it doesn't apply directly in case of Delhi government. Legislative Assembly there will not be having powers to make laws, and the executive power of Delhi government is the same as the legislative power. Only in those areas in which it has legislative powers, it can have executive power only for such areas. So it is coterminous, means the executive power cannot go beyond the legislative power as far as Delhi government is concerned. So if Legislative Assembly doesn't have power to make law on a particular subject, Delhi government cannot make executive orders or take executive actions in that subject, like transfer of officers belonging to DANICs, DANIPs and other areas. So that in that case, the decision has to be referred to the LG. Now, 3 subjects which are now coming further to the competence of Legislative Assembly, 3 subjects which are directly excluded are 1, 2 and 18. It is police, public order and land. These are excluded, means Delhi Assembly has no powers to make laws on these 3 subjects. Also 64, 65, 66, insofar as these 3 subjects are related to 1, 2 and entry 1, 2 and 18. What are 64, 65, 66? 64 deals with the power to make laws for the offences pertaining to the subjects which are mentioned in the state list. But if those offences are related to these subjects, the Legislative Assembly of Delhi doesn't have power to make laws. Then what is 65? 65 gives powers to the state government for, basically it is about giving powers to the court, excluding the powers of Supreme Court. Regarding Supreme Court, state government doesn't have any power to make law. Even for High Court, it can't make such law which derogates its power. So that is also not permitted. But for like other court mechanism, for other judicial mechanism, the powers are given to the state government by the virtue of entry 65. But here also this power is curtailed for Delhi government insofar as that relates to these 3 subjects. And entry 66 pertains to fees, etc. That is also not allowed when it relates to 1, 2 and 18. So effectively we can say 6 subjects are taken out and the other subjects will be applicable as far as they are applicable for union territory. Means everything which is applicable for state government may not be applicable for National Capital Territory of Delhi just because that subject is mentioned in the state list. So that is for the competence of assembly. Now we come to the executive part. This is the legislative part. The executive part is also defined in Article 239, is also explained in Article 239, and that is explained in Article 239AA Clause 4. So I have covered 239.3, now I come to Article. I have covered 2, I covered 3, now 239AA Clause 4. It deals with Council of Ministers. So Council of Ministers, they are there to aid and advise LG. However, wherever LG is given power to act in his discretion as per law, there LG will not act as per the aid and advice of Council of Ministers. So barring those areas which are provided for by law made by Parliament, excluding those areas, the LG will function on the aid and advice of Council of Ministers. Now here the friction started on the proviso to this article. So proviso to this clause, not this article, proviso to this clause says that if there is a difference of opinion between the LG and his ministers will mean government. So if there is a difference opinion, what happens in that situation? So there the LG will refer the matter to the president, and if the matter is urgent, the LG can, pending the decision of the president, LG is empowered to take a decision in that case, in that situation. So, but the word which is mentioned there is, if there is a difference of opinion in any matter is important. When this issue went to Supreme Court, the friction between LG and the Delhi government went to the Supreme Court, and the Supreme Court said any matter here doesn't mean every matter. So there is a difference between any matter and every matter. So in routine, the LG should not be having this difference of opinion and taking decision or referring the matter to the president, not in routine, only in certain situations which call for, and that decision has to be taken by that constitutional functionaries based on his responsibilities which are bestowed to him by the constitution. So the Supreme Court basically expected a more responsible approach, more responsible behavior on the provisions, on the actions which emerge from the provisions of the constitution. So every matter is not to be referred. Every matter will not, LG cannot say that this decision has not been, it cannot be taken, because Supreme Court clearly gave an edge to the elected representatives. Decision of the elected representative or the elected body should not need approval of LG in all the cases. Maybe there may be certain matter of national importance or security or something else calling for reference to be made to the president. In such case, the reference can be made. Now there are other interesting comparisons which we can make, which I would like to make between Delhi and the state, other states. Now as far as the other states are concerned, the Council of Ministers is covered by Article 164. The ministers in state are appointed by the governor, of course, on the advice of the chief minister. But here the ministers are appointed by the president, not the LG. There it is appointed by governor. And in both the cases, in case of Delhi and in case of states, they are responsible, the Council of Ministers is responsible to Legislative Assembly. So here also that similarity is there, but the difference is here appointment is by governor and they are accountable to governor as far as individual ministers are concerned, and here it is president, but collectively they are responsible to the assembly. Another distinction which is there, this was a similarity, before that I covered the distinction, now I cover another distinction. In case of states, the total strength of Council of Ministers is up to 15%, but in case of Delhi it is 10%. In states it is 15%, and the minimum number in case of state is 12. In case of Delhi, the percentage is mentioned as 10% of the total number of seats in the assembly. So it is 15% of this. Suppose some state has 60 seats, it will be 15% of that 60, and in case of Delhi it will be 10% of the number of seats in the Legislative Assembly. So that is as far as the basic executive and legislative power is concerned and the friction points. Now let us come to one important aspect, which is the power to issue ordinance. We know that in case of states, the governor can issue ordinance when the assembly is not in session and there is a need, situation as such as has arisen where the ordinance is to be issued. So this is possible in case of both Puducherry and National Capital Territory of Delhi. The ordinance can be issued by the LG, but it can only be done on the instructions of the president. So instructions, without obtaining the instructions of president, ordinance cannot be issued by the LG of both Delhi and Puducherry, and the other exercise, getting it approved within 6 weeks of the first sitting of the assembly, as it is in the case of states. I have already covered in that lecture for the state governments, for the states, the ordinance making power of governor. The other provisions are similar, means you can't make ordinance on a subject which is not the legislative competence of the assembly. So only like you have a legislative competence, only on those subjects the ordinance can be passed, and the ordinance can only be passed after obtaining instructions of the president, and of course it will be based on the advice of the Council of Ministers of the respective government. It can be Puducherry, it can be Delhi. Now, other interesting thing which I would like to mention is that in one of the friction points which was there before the Supreme Court also made a reference to Schedule 12, where the fire service is mentioned, and said that if the Delhi government takes certain executive orders, takes certain executive decisions in case of fire service, it is not by the virtue of entry 41, that is service in the state list, but it is by the virtue of the entry pertaining to fire service in the state list, and also the fire service as far as Schedule 12, that is the role of municipality is concerned. So that way a parallel is drawn, means the power of Delhi government is not equal to the state government, but is also not like municipality, but it can be compared to the power of municipality, because Schedule 12 was referred in one of the cases by the Supreme Court. So by and large, these are the articles I wanted to refer. There are so many things, but then the lecture becomes exceedingly lengthy. I want to confine it, and you should also not be bombarded with so many articles.